Hello, everyone. This is Scott Goldstein. I'm a bankruptcy attorney, and I wanted to talk to everyone today about something that's been coming up a little bit in my practice and has happened many times before, but it's something that's been on my mind recently. What's the obligation of an individual who is going to a personal injury attorney to disclose that they're in a bankruptcy petition or bankruptcy case? Or what is their obligation to disclose to the bankruptcy attorney that they are in a personal injury case? More importantly, and this is from my fellow attorneys in the room, what's the obligation of a personal injury attorney to ask their client about bankruptcy? Let's go to the debtor, the bankrupt person's obligation. Every attorney who does a bankruptcy case will ask, are you in a personal injury case? Do you have a pending personal injury case or other lawsuit going on? I have a very simple question. Is any other lawyer working for you besides me? And then I can go from there. Good. What's it about? It is incumbent upon anyone who is filing for bankruptcy or in an active case to disclose personal injury cases or any other lawsuit they may have. Why is that, you may ask? Because if you're in bankruptcy and you are going to recover money from a PI case, depending on the kind of bankruptcy you have and the amount in question and the timing of the injury or other wrong that was done to you, that may be part of your bankruptcy estate and may be subject to the claims of creditors in that bankruptcy. If you don't list the asset, i.e. the personal injury case, the med mal case, whatever it is, you could lose that lawsuit by operation of law, because if you don't list it on your petition, you are saying to the court in a sworn document that you don't have a claim, that there is no claim. Now, if you don't know about the claim, like say you've got a personal injury that is from a long-standing exposure to something, or you fail to understand what's going on, you can amend later to add it. But if you just flat out don't bother, you lose your case automatically. It's a sworn statement. You are precluded from arguing in a later document that you do in fact have a claim when you swore to a court that you don't have one. Now, personal injury attorney friends out there, this part's for you. If you are a personal injury attorney, I would say that it, as a matter of inquiry and for your own protection, it is incumbent upon you to ask your potential client, hey, by the way, are you in a bankruptcy of any sort? Or get yourself signed on to Pacer, get yourself a Pacer account, and have your paralegal take 10 seconds and $1 to search and just verify, especially if you've got your client's social. If you've got your client's social, you can pull up a bankruptcy case and check it on Pacer and make sure that your client's not a debtor in a bankruptcy. And if they are, then refer them to your local friendly bankruptcy attorney to consult. If they're, refer them back to their bankruptcy attorney to consult about what's going on. Because there have been recent cases where a personal injury award was given in a personal injury case that after it happened, all of a sudden, oh wait, I'm in bankruptcy, and it comes out, now they want to go back and address the issue, but the personal injury attorney's taken their fee, and the court has actually caused the personal injury attorney to disgorge their fee as not being allowed, so you have just done all that work for nothing. And indeed, you may have committed malpractice, especially if the debtor loses all that money, where it might have been possible to exempt things out or to protect things. If you don't do that, you've got a major problem. So from the debtor side, it's incumbent upon you to disclose, both to your personal injury attorney and to your bankruptcy attorney, the cases and how they all work together. And they'll know how they work together. And for personal injury attorneys, practice point for you, you should always ask. And you should do your own independent investigation as part of your due diligence as to whether or not your client is in a bankruptcy. And if they're not in the bankruptcy yet, ask them if they've consulted a bankruptcy attorney or thinking about it, because usually if you're in a personal injury situation, you might have some financial issues at that point too, because you're unable to work, you've had a significant loss. Ask. It's better to ask and be told, nope, we're good, why would you ask? Then not ask and have it turn around and bite you 8 months, a year later. So that's my point for everyone today. I do hope this is helpful, and thank you very much for listening.